Okay, good morning. What we're going to do is we're going to start a 2-week unit on contract law. And the reason I chose to start it this week is so that you won't have anything due while you're on spring break. I will lecture today and Thursday, so the only thing you guys have to do this week is read the outline. When you get back from spring break, then we'll have a whole nother week finishing contracts, and then after that week, you'll have a quiz. So really nothing to do this week except for come to class and read your outline. I purposely did that. Hopefully that'll make this week and next week easier and more enjoyable for you since you're on break. There will be a discussion question, but I'm not probably going to post it maybe until the second week of the unit. And then I got asked this by somebody in my online class, so I'm going to explain again. Your discussion questions all put together are worth one assignment grade. I don't grade it till the end of the semester. So I'm reading what you're writing, but I'm not going through and assigning any grade until the end of the semester. The grading is based on effort. Did you answer the question? Is it your own thought? Is it not AI? I don't have to agree with it. I don't have to think it was a great answer. As long as it's your answer, I'm going to give you 100 for that. So if you did, let's say we had 10 discussion questions and you did all 10, you get 100 for that assignment. If you did 8 out of 10, you'll get an 80. If you did 6 out of 10, you'll get a 60. So that's all that put together is going to be worth one assignment grade. But I will let you know at the end of the semester when all of them have to be done. I'd like for you to do your discussion questions as we go because it's more meaningful. But I realize that this is just one of those things that I'm not grading every week. So I'll just grade it at the end of the semester. All right, so yes, sir, question.
Are you going to answer some of those questions we asked in the discussion?
Yes. Am I going to, on the ask a lawyer questions? Mm-hmm. I am going to do that. I just need to set aside a day for that or some time. And I haven't got there yet, but I will. Want to remind y'all too, don't forget about your career prep stuff. Don't wait till the end of the semester on that. They'll get full and you may not be able to get all the appointments you need if you do that. So make sure that you're still working on that. There's going to be, I'll remind y'all of this again, but you'll come back from spring break for a week. We'll finish contracts. And then that next week, I'm going to be gone and we'll just have virtual class that week, but it'll be a reduced subject matter and content week. So you'll have that week to really get back on your career prep as well. So you're going to have some chances to do it. That's kind of built in, but please don't wait till the end. All right, so let's talk about contract law. This is one of the units that you'll find has application to your personal and professional lives. I'm going to begin talking with just some general things about contract law, just some overview kind of topics. So a contract, by definition, is a legally enforceable agreement between two or more parties. They promise to do something or they promise not to do something in exchange for the other party doing or not doing something. So it's a set of promises that the law will uphold. We're going to get into detail on the 4 elements of a valid contract. But I want to tell them to you at the beginning, just as overview. The 4 elements of a valid contract are agreement. That means we have an offer and an acceptance. Consideration. Both parties are giving up something of value. Legality. The contract has to have a legal purpose. And the 4th element is capacity. The parties have to have the ability, the mental capacity or the legal capacity to enter into a contract. Again, we're getting into these in much more depth. So briefly, consideration. Hold on, got a question. Caleb.
Can you say the first two again?
The first element is agreement, and the second element is consideration. Briefly, consideration means that there has to be something given up of value from both sides. Consideration distinguishes a contract from a gift. All right, if I offered Caleb to sell you my truck for $20,000, the consideration from me is the truck. You're getting a truck. The consideration on your end is the $20,000 that you're giving me, right? If I offer to give you my truck, there's consideration on my part. I'm giving up the truck, but there's no consideration on your part because you're not giving up anything. That's a gift. That's not a contract. We're going to get into consideration pretty deep on Thursday. The idea of capacity is important because if a person has diminished mental capacity, they might be developmentally disabled, they might be under the influence of alcohol or drugs or medication, and they lack the capacity to understand what they're contracting for. That might negate a contract. The law gives legal capacity at age 18 to enter into contracts. But before age 18, it takes away the ability to contract. So we might have a 16-year-old who has no disabilities, who's the smartest 16-year-old around, but the law says they don't have the capacity to enter into contracts. So that's the element of capacity. And then the element of legality is that you can't make a contract for something that's illegal. Easiest example I can think of on that is I can't hire a hitman to kill Corbin. Got his attention. I can't hire a hitman to kill Corbin because murder for hire is illegal. So even if me and the hitman had a valid contract in every other way, I can't go to court and enforce it. Okay? So the purpose of contract law is to give some certainty and some predictability to private citizens and private businesses' ability to enter into contracts. We wouldn't do it if we couldn't enforce it. Business would not work very well if no one was held to the agreements that they make. No one would do deals. No one would enter into contracts if they had no meaning, if they couldn't be enforced. So it protects expectations. I know that if I enter into a contract and I make a payment, that if the other side doesn't do what they're supposed to do, I can enforce that. I'm not going to be left out in the cold hanging. It encourages economic activity, right? Businesses are going to enter into contracts if they know that they're enforceable. It promotes fairness. And it gives us a remedy if somebody doesn't do what they promised they would do. I want to talk to you for a second about something called the Uniform Commercial Code. So, and I'm going to tell you the three things I want you to know about the Uniform Commercial Code by the time I'm finished talking about it. But this is what it is. So contract law is state law. Each state gets to decide what their own contract laws are. All right? That could present a huge problem for anybody or any business who does business in other states. It would be very problematic for me as a business owner to have to worry about the contract laws of each of the 50 states. So in order to clear up that confusion, the states got together and said, we're all going to adopt the same laws when it comes to contracts. It's still state law. It's just that each state said we're going to adopt the exact same code of contract law. Okay, it's called the Uniform Commercial Code, the UCC for short. The UCC has broad application in business. We don't get in too much into the UCC here because it would take all semester. Okay, so what I want you to know about the UCC is that it is a uniform set of laws that's been adopted by each of the 50 states so that contract law across states is uniform. That's one thing I want you to know. The second thing is that it applies to the sale of goods for price over $500. So any contract for the sale of goods for an amount over $500, the UCC applies. Any contract that doesn't fit that definition, the UCC doesn't apply. So the UCC is going to have a pretty broad application in your business careers if you're involved in the sale of goods. And what I want you to take away from this is that you're going to need to know, you're going to need to think to yourself, I need to know more about the UCC. Most of my contracts are going to be governed by the UCC, so I need to be a little more knowledgeable about that. I wish we had time in this class to get deeper into it, but we don't. So those are the things I want you to know. It's a uniform set of laws that each of the 50 states have adopted that apply to contracts for the sale of goods over $500. That's as deep as we're getting into. All right, the next thing I want you to know is that I want you to listen carefully to this. All contracts do not have to be in writing to be enforceable. Some contracts do, but not all of them. So it's never a defense to say we didn't have an enforceable contract because it wasn't in writing. That might be true in some instances, but not all. So I'll say that again. Not all contracts have to be in writing to be enforceable. That means we can have an enforceable oral contract in some situations. In some situations, we can have a contract where no words were spoken at all. I'm going to get to that in a minute. Now, having said that, just because all contracts don't have to be in writing does not mean that you shouldn't always put your contracts in writing. You should always put a contract in writing to protect yourself. You don't always have to, but it's best practice, and it can avoid many of the problems that we're going to talk about in this unit. All right, we can have an enforceable contract. And when I say an enforceable contract, that means a contract that I could go to court and have the court recognize as legally binding and force both sides to perform their obligations under the contract. That's what I mean by a legally enforceable contract. It means I could use the court to enforce it. We don't always enforce contract law in court. And I want to talk about why we might not do that. Okay? The first is because of the cost of enforcement. So let's say that that Mr. Griffin and I agree that he will give me a ride to my office after class, and I will pay him $10. Okay? We have an agreement. I've offered, hey, I will give you $10 if you give me a ride. He says, you've got a deal. That sounds great. I will give you a ride for $10. We have offer and acceptance agreement. There's consideration on both sides. He's giving me a ride. I'm paying him money. It's legal for us to do that. And we both have capacity. So we've got a legally binding contract. What happens when I get out in my office and say, too bad, sucker, you'll never see that $10? Could Mr. Griffin take me to court to enforce that contract? He could, right? We have met all the elements of an enforceable contract. Why might he not do that? other than he's worried about his grade. Why might you not take me to court for that $10, Mr. Griffin? Over $500 is for the UCC to apply. And that's also for the sale of goods. So that wouldn't apply to this contract. But I like the way you're thinking. I mean, he could go down and sue me and tell the judge, we had a valid contract. Here's all the elements of it. I performed my obligation. He didn't perform his. He owes me $10. The judge would probably say, or the judge would say, Tebow, you owe Mr. Griffin $10. Pay him. Why might he not go through all that trouble? Is it worth it? Is his time worth it to recover $10? It's certainly not worth him hiring a lawyer to recover $10. It might not cost him much. You do have to pay a little filing fee to sue somebody. It's going to be more than $10. But that might take him a couple hours. Go downtown, go to the court, get the paperwork, fill it out. Then he's got to get a court date. Then he's got to show up to court. Then he's got to prove to the court that we had this contract. All for $10. Maybe not worth it. Okay, so we do have an enforceable contract, but that doesn't mean he's actually going to go to court and enforce it. There's a business relationship factor that will cause people sometimes to not go to court over contract law. Let's say that I am a store owner and I have a supplier we have a contract that I will pay the supplier X amount of dollars in exchange for them delivering this certain product by a certain time. Let's say that they're late delivering it. They have breached the contract. They did not uphold their end of the contract. Am I going to actually go to court over it? Probably not, for the same reasons we talked about before. Economically, it might not make sense. Maybe I really like the supplier, and I'm fine with it being late every once in a while. Maybe I could go to court and I could tell the court that the supplier didn't deliver on time. Remember, in civil law, I got to have damages. What are my damages? Well, maybe the delivery was a couple hours late, but it didn't really cause me any damages. Is that going to be worth it for me to go sue this person when I really don't have much to recover? Probably not. All right, so those are those considerations. There's also sometimes a problem of proof. So hopefully by now you're in the right mindset of whenever we go to court, that plaintiff has to prove their case. All right, they've got to prove that there was an enforceable contract. If Mr. Griffin and I, in our contract for him to give me a ride, let's say it was all oral, nothing was put in writing, and nobody else heard us. He's got a proof problem at court because I could lie and say, I never said I'd give him $10. Or, I gave him $10. I don't know what he's talking about. All right? So, those are issues of sometimes why folks might have a good case for breach of contract, but they don't go to court to enforce it. Sometimes it's in a business or a person's best interest to break a contract. We call that efficient breach. What if I'm a home builder and I can only build one home at a time? I've got a small crew and I'm under contract to build a house for $200,000. That's the price I'm going to get paid. And somebody calls me up and says, hey, I need you to build this $3 million house, but you got to start tomorrow. And I think to myself, ooh, if I take this big job, I can't do the little job. But you know what? I think I'm just going to cancel on the little job. And if I have to pay a little bit of damages to that person if they sue me, I'll still come out ahead because I'm going to make more money doing the $3 million job. So from a business standpoint, I might breach that contract on purpose. All right, so those are reasons why just because we have a valid enforceable contract, we might not be going to court. When we do go to court, the jury, the judge, the law, in evaluating anything having to do with contract law, whether there is a contract, whether somebody made an offer, whether it was accepted, what the terms were, what the intent of the parties were, what the subject matter is, all of that is measured in court by the objective theory of contracts. Okay? What that means is that the court is only going to consider objective evidence. What was said, what was written, what the circumstances were, what somebody heard, what somebody saw, what work was performed, how much something cost. What the court and the jury is not going to consider is subjective evidence. I thought the car was worth more than that, so that's why I paid $50,000. If I'd known it was only worth $45,000, I wouldn't have paid $50,000. Too bad. I know I said I ordered 40 bushels of peas, but I meant to order 4 bushels of peas. I just misspoke. I didn't mean to order that many. That's subjective. The court does not care about that. Oh, I know that I promised to pay Mr. Griffin for giving me a ride, but I didn't, that's not what I meant. I said $10, but I didn't really mean that. I was joking. The court is not going to accept any of that as proof, because how would we get out of contract? If you could use subjective evidence to get out of contract enforcement, what would we do then every time we went to court? We just say, that's not what I meant. That's not what I thought it was worth. That's not what I intended. Yeah, I know I said that, but that's not what I meant. Okay? Subjective evidence doesn't matter. We have to have it that way so that we can have predictability in our business dealings. If somebody could get out of a contract just by saying, I didn't mean that, you misunderstood me. It's not what I meant. Then we would have, then the foundation of contract law would crumble because there'd be no enforcement. So that's the objective theory of contracts as it applies to everything we talk about in this unit. On item number 8, freedom to contract. Even though we do have laws about what makes an enforceable contract, we don't have many laws, if any, about what we can enter into contracts for, so long as it's legal. We have the freedom to enter into contracts however we want to, right? If I want to pay Mr. Griffin to drive me downtown after class, I'm free to do that, okay? If I want to buy 40 bushels of peas from a supplier, I can do that. If I want to pay somebody $10 million to build me a house, I can do that. As long as it's legal, we get to make our own deals. We have freedom to do that. Flip side of that is that as the law gives us freedom to make our own deals, the law does not get involved if we make a bad deal. All right, we have the freedom to enter into whatever contracts we want, and the law presumes that whatever contract we enter into, that's what we wanted to do. Let's say that I have a $50,000 car. It's brand new. And I offer to sell it to Corbin for $20,000. He brings me a check for $20,000. I give him the title to my car. That's a terrible deal for me, right? On its face, it is. But I can't go to court and say, Judge, you got to help me out here. I got shafted in this deal. He just got a $50,000 car for $20,000. The court's going to say that's your problem. You shouldn't have entered into the contract. You have the freedom to do that. You know, maybe my bookie told me that I better come up with $20,000 by lunchtime or he's going to break my legs, kill my dog. Maybe my motivation was that I wanted $20,000 by lunchtime and I didn't care how I got it. Court's not going to get into what my circumstances were. So we have the freedom to contract, and courts do not rewrite bad bargains. All right, so that's kind of all the overview stuff I wanted to talk about. Now let's get into the elements of a valid contract. First element is agreement. I'm going to do agreement for the rest of the class today. We'll talk about consideration and capacity on Thursday and maybe legality. And if I don't finish everything, we'll bleed over to that week after spring break. The rest of today is agreement. In order to have agreement, we have to have a valid offer and a valid acceptance. Okay, that makes sense to us, right? In order to have a valid offer, the offer has to meet certain requirements. It has to be definite. We've got to be able, if we have a dispute about what the contract was about, the court has to be able to figure out what the offer was. If we have a dispute about whether or not there was an agreement, okay, it's got to be definite. It's got to be serious. That can be a little tricky, okay? Am I serious if I say, Corbin, I will sell you my car? If I say to you during class, y'all, I've got this extra car. I don't really need the money. I just want to get rid of it. It's been taking up space in my garage. It's probably worth $50,000. I'd be willing to sell it for $20,000. Corbin, I'll sell it to you for $20,000 if you're interested. And he says, deal. He brings me the check the next day. I give him the title. Does that seem like serious intent on my part? Yeah. Right? I mean, it is unusual for me to be worried about selling a car in a classroom, so that's a little bit funny. But let's say that Corbin runs into me at 3 a.m. on Saturday night downtown, and I'm hammered. I can't stand up. I'm slurring my words. And I offer to sell him my car for $20,000. Is that serious intent? Not as serious as my offer I made in the classroom, right? So the circumstances, the facts and circumstances, the objective evidence would be what the court uses to assess whether or not I made a serious offer, whether my intent was serious. Okay? Let's say that Corbin sued me because I refused to sell him the car, and he says, we had a contract and you breached it. My evidence is going to be that I was hammered. Maybe I've got witnesses that I bring in to be like, he was completely incapacitated. He couldn't walk. We had to take him home. He ended up in the hospital from alcohol poisoning that night. I don't know. Right? When the judge or the jury applies the objective theory of contracts, they do so wearing the hat or looking through the lens, the glasses of the reasonable person. Would a reasonable person believe that my offer to sell my car to Corbin in class was serious? I mean, we would put up our objective evidence and the jury would decide. He would have a lot better chance arguing that a reasonable person would think that I was serious in the classroom example than he would if he tried to argue to the jury that any reasonable person would have thought that my drunken offer was serious. Okay? So all this objective evidence gets viewed through the glasses of the reasonable person. So an offer has to be definite. It has to be serious in intent. Your outline then goes into some situations and times when an offer is not definite and not serious. Okay? It's not just something indefinite would be, I'll sell you my car, Corbin, for $20,000. That's not definite enough. We don't even know which car we're talking about. All right? Other ways that we don't have serious intent are expressions of opinion. Corbin says, Professor, I think your car is worth $50,000. I cannot then say deal. You just bought it. We got it. We just entered into a contract. That's an expression of opinion. I sure do like your car. I've always wanted to buy a car like that. Too indefinite to be an offer. Statements of future intent are not offers. I tell the class, hey, I've got this car and I'm not ready to sell it yet, but sometime next year in 2027, I'm going to sell it for $20,000. Corbin brings me a check and says, deal. That is not a definite offer because it was an expression of future intent. Preliminary negotiations are not offers. Caleb says, are you interested in selling your car? Yeah. I mean, everything has a price, right? We have not entered into a contract. That was preliminary negotiations. He didn't make a concrete offer to me. He just said, are you interested in selling your car? Would you ever take $50,000 for that car? Yeah, I probably would. That is not an agreement. He didn't offer me the money for my car. He just says, would you take it? All right, so the words matter. Now, there's not anything that if you want to make an offer to somebody, you can't go to the law and say, hey, give me a checklist of give me the magic words that I have to use to make this a valid offer. It just has to meet the definition of serious intent, and it has to be definite enough. It can't be an opinion. It can't be preliminary. The actual words you choose are up to you. Invitations to bid, like a lot of government contracts are handed out by who submits the lowest bid. So if I were to say, I'm president of CSU, we need a new building built, I'm going to take bids from contractors, and I will award the contract to the lowest bidder. Just because I invited someone to bid and they make a bid does not mean we have a contract. I have to actually award them the contract based on their lowest bid. Advertisements and price lists, yeah, I said that right, are not an offer. That's a little bit counterintuitive to some of the stuff we're talking about, because if Best Buy is offering to sell this laptop for $500 and I get down there and they're charging me $600, that doesn't mean they can get away with it. It just means that I can't sue them for breach of contract. I could sue them for the civil tort of fraud, right? They've misrepresented something. So it doesn't mean they get away with that. It just means that my remedy, what I sue them for, is not breach of contract. I can't go to court and say, well, they advertised it for this, and I was willing to pay that, and so therefore we had an agreement. Advertisements and price lists are not offers. When we talk about the definiteness of an offer, We talk about things like it needs to specify who the parties are. It needs to identify the subject matter of the contract. It needs to spell out what the consideration is. If there are any terms about title or getting financing or delivery, those kind of things would need to be spelled out. So if Corbin and I do decide to do a deal for my car, and he makes me an offer, he should first do what? How should he make that offer? What's the best practice for making an offer? What's the best mode of communication? Put it in writing, right? He should definitely put it in writing. If he doesn't put it in writing, we already have a problem because we can disagree about what we said. If he puts it in writing, we can't disagree about that. So if he wanted to make it definite enough to be enforceable, he would say, I, Corbin, offer to buy your car, Professor Tebow. In fact, I wouldn't say car. I offer to buy your 2002 Honda Civic. VIN number this. I might even put the color in there. For $10,000. Which I will pay within 5 days of your acceptance, and you will deliver the car to me at the time I make the payment. That's identified the parties, it's identified the consideration, it's spelled out the subject matter of the contract, the offer. All of those are helpful because, again, we're not necessarily viewing whether or not we've got an enforceable contract on the front end. We're really only worried about that on the back end if somebody didn't do what they were supposed to do. Let's say that we have a contract for the sale of land. That is one of the categories that has to be in writing. We're going to talk about that later, so don't get hung up on that. But let's say that I offer to sell Corbin my farm for $100,000. We don't put anything in writing. He gives me the $100,000, or we agree to it. He gives me the $100,000. I give him the deed to my farm. It doesn't matter that we didn't do it right. We did it. We can't undo that. The only time we're looking back to see if there was an enforceable contract is when one party thinks there isn't, or there's a disagreement about performance. So it's evaluated on the back end. We can do a contract that ought to be in writing that isn't in writing as long as we're both fine with that. We just would understand that neither one of us could go to court and enforce it. So the offer has to be definite. It has to be communicated to the offeree. So if I say to you all, members of my 11 o'clock business law class, I'm willing to sell my 2002 Honda Civic to the first person who brings me a check for $5,000. All right? I go up to my office, and Miss Jackson is the first up there with her check for $5,000. We have a valid offer and acceptance because I communicated that to her. She accepted it. Let's say that one of your friends shows up in my office after class with a check for $5,000 saying, hey, I heard you're selling a car. Here's your check for $5,000. I didn't communicate my offer to your friend. I communicated my offer to members of my 11 o'clock business law class. So it does matter who it's communicated to. Now, an offer, once it is made, can be terminated. It is not required to be left open until the offeree either accepts it or rejects it. How does an offer get terminated? The easiest way an offer gets terminated is when the offeror, the person making the offer, says, I revoke my offer. That offer is no longer on the table. Never mind. Again, if we have a dispute about whether or not I revoked my offer, who's going to be the judge of that? The jury. And they're going to look at the objective evidence through the lens of the reasonable person and decide whether or not I revoked my offer. If I say something like, hey, Mr. Griffin, I made you an offer this morning to buy my car for $50,000, I revoke that offer. That jury wearing the reasonable person hat is going to say a reasonable person would pretty much understand that offer was revoked. If I said to Mr. Griffin, I don't know, if I just laughed at him, and I think in my head, I was terminating my offer. I was revoking my offer. Maybe, but it's going to be up to the jury looking through the lens of the reasonable person as to whether a reasonable person would think I revoked my offer or not. All right, so it can be terminated by revocation. It can be terminated by action of the offeree, the person it's made to. How can they terminate that offer? By rejecting it. Mr. Griffin, I'll sell you my Lamborghini for $50,000. No. Offer's terminated. What if he brings me a check for $50,000 the next day? Could he then argue that that's acceptance? He can't, because he terminated the offer when he rejected it. What happens if he says, okay, I make the offer, I will sell you my Lamborghini, Mr. Griffin, for $50,000, and you say, I will give you $40,000 for it. That is a termination of my offer. Because that is what's known as a counteroffer. And a counteroffer terminates the original offer and becomes a new offer. So now what we have in that situation is my $50,000 offer is done. He has made me an offer to buy my car for $45,000 that I could then accept. What if I say to him no, or I don't say no, I say I'll sell it to you for $48,000. Now I've terminated his counteroffer and I've made another counteroffer. All right? Let's say that we don't come up with any deal. He says no. The next day he comes back and says, here's $50,000. I accept that. Remember when you offered me your car for $50,000? Well, I accept. Too bad. That offer that I made has been terminated just as soon as he made a counteroffer. If he does show up the next day with a check and says, I want to buy your car for $50,000, he's making me a new offer. I could accept that. But neither one of us could go back and bind the other to a deal where a counteroffer was made. So like I can't say, hey, sell my car for $50,000. You say, I give you 40. I say, forget it. You say, okay, 50. That's not a contract. That's not an offer and acceptance until I say yes to his offer at 50. Even though I offered him 50 before. He terminated my offer when he counteroffered. All right, another way that an offer could be terminated is if a certain amount of time passes. If the offer specifies that the acceptance must be made within a certain time period, and that time period lapses, then the offer's terminated. Will, I'll sell you my Lamborghini for $50,000, but you have to accept by Friday. He shows up on Saturday with a check, no deal. No deal. Now again, could I accept his check on Saturday? Do we have an offer and acceptance then? We do. It's just a different offer and acceptance than the original. The original was me offering to him and he didn't accept. Him showing up late was him making a new offer to me, and if I'm good with that, I can accept it. So by operation of time can terminate an offer. The law could change and terminate an offer. let's say that I want to sell Ian this exotic pet snake that I got from India. And I make the offer to him, and I say, I'll leave this offer open till Friday. And on Thursday, Congress passes a statute that says it's illegal to sell or have these snakes as pets. And Ian shows up on Friday and is like, I accept your offer to buy that snake. My offer has been terminated by operation of law because now what I offered to do is illegal. I can't go through with it because the law doesn't allow it. That terminated my offer. That doesn't happen very often, but it could happen in the business world in terms of like construction, maybe like I offer to build something and then the city changes the zoning laws to where we can't build that anymore before the offer is accepted. That would be a better example than the snake of an offer being terminated by operation of law. An offer terminates if the subject matter is destroyed. So I'm offering to sell Miss Rivera this Lamborghini. I don't put a time period on her having to accept. 2 weeks go by, she hasn't accepted yet. I total my Lamborghini in a fiery crash. She decides she wants to buy it. She shows up with a check. My offer's been terminated. There's nothing for her to accept because that doesn't exist anymore. You don't have to put a time limit on acceptance. You should. Because if I offer to sell you my car and I don't put a time limit on it and you show up 6 months later with the check, the jury might enforce that. Is it reasonable that a person could think that the offer was still open? I don't know. You guys see me driving in and out of school in the same car. I never did anything else to revoke my offer. If all of a sudden, if Will buys my car and writes Will's car on it, okay, and y'all see him driving it, and I never did revoke my offer, then it wouldn't be reasonable for you to think that you could still buy that car from me. Number one, I don't own it anymore. That would have terminated my offer when I sold it. Now, there is a way to make an offer stay open. It is called an option contract. That is when the offeree, the person that the offer is made to, pays money or gives some consideration, something of value to the offeror in exchange for keeping that offer open and not selling the thing to somebody else. In essence, what they've got is a mini contract regarding keeping the offer open. Ian, I will sell you my Lamborghini for $50,000. And you say, Professor Tebow, I need to think about it. I got to see if I can get financing. I got to come up with the money. But I don't want you to sell it to anybody else. So I'll give you $500 if you leave your offer open until next Friday. What we really have is a mini contract. He's given me $500 and I've agreed to keep the offer open for that period of time. If that period of time runs and he hasn't accepted, I keep the $500. He doesn't get to buy the car. But I am bound to accept his acceptance if he does accept it within the time period that he paid me to keep it open. Does that make sense? So an offer does have to stay open if there's consideration given by the offeree. You see this in real estate contracts. I want the option to buy your house. It's very common. We're going to put it under contract. I'm going to give you some earnest money. I'm going to do my due diligence for 30 days. I'm going to see if I can get my financing. I'm going to get it appraised. I'm going to get the inspector over here to make sure there aren't any big problems with it. And during that 30-day period that I have paid you money to keep open and not sell it to anybody else, I could accept the offer if I want to. And you'd be bound by it. So that is offer. Let's get into acceptance a little bit. Acceptance is a voluntary act by the offeree that shows agreement to the offer. Notice I didn't say writing or words, although those are valid forms of acceptance. The best form of acceptance is a written one, right? Especially if you're the offeree. I'm putting what I'm agreeing to in writing back to you so that you can't say that wasn't what we meant. I could do it in writing. We could do it orally if it is the kind of contract that is acceptable to have an oral contract. But I also could do it by actions. Let me give you an example of that. I walk into, anybody in here work in food service? Where do you work? All right, when you worked at Chick-fil-A, and I called up Chick-fil-A and ordered 4 nugget trays for my kid's birthday party. And you took my order, you wrote my name down, I showed up, you give them to me. I refuse to pay. I say, we didn't have a contract. He never said, I will cook 4 nugget trays for you in exchange for $84, right? I didn't say, hey, I'll pay you $84 for 4 nugget trays. I just ordered 4 nugget trays. He gave them to me. I owe him the money. We all know that, right? But we never had the conversation specifically about an offer and acceptance. So conduct can imply a contract. I go into a restaurant and I order off the menu. The waiter never says, hey, if you order something off that menu, we'll bring it to you, but you got to pay us whatever the amount is on the menu. I don't go in the restaurant and say, hey, if you bring me X items from the menu, then I will pay you X amount for it. We never have that conversation. But we know if we go in a restaurant, order the food and eat it, we owe the money for it. So offer and acceptance can sometimes be formed by conduct. Would a reasonable person, if you're in the jury and I don't pay for the nuggets and Chick-fil-A sues me, is the reasonable person hat wearing juror going to say, yes, a reasonable person would have expected if you call up Chick-fil-A and order nugget trays and show up and they give them to you, you owe them the money. Of course. All right, so acceptance doesn't always have to be verbal or written. It could be through conduct. Acceptance usually needs to be made in an unequivocal way. All right, Ian, I'm going to sell you my Lamborghini for $50,000. You say, maybe. That's not acceptance. That's not unequivocal. You could say, yes, always wanted a Lamborghini. That's not clear acceptance either. Right? So it generally needs to be unequivocal. when you think of it in terms of the restaurant example, I order the food, they bring it, I eat it. That's pretty unequivocal, right? We know the intent based on my actions. So it needs to be clear. It's got to be communicated to the person who made the offer. And it's got to be made in a reasonable mode. So if I put on Facebook Marketplace that I'll sell my car for $5,000, and you message me through Facebook Marketplace saying, I accept your offer, that's a reasonable means of acceptance. If I put on Facebook Marketplace, I'll sell my car for $5,000, and you send me a letter in the mail saying I accept your offer, I mean, it's still murky, but not as reasonable. If you send it to me by carrier pigeon or smoke signals, that is not a reasonable means of communicating acceptance. If I made the offer to you by carrier pigeon, then it would be acceptable for you to accept by carrier pigeon. Okay? But the acceptance needs to be communicated in a reasonable mode that fairly matches the mode that the offer was made in. All right, what else did I want to say about agreement before we're done? I mean, about acceptance. There's one other thing. Acceptance could also be made by performance. All right, Ms. Rivera, I will pay you $20 to take me to my office after class. Okay? You never say, I accept your offer, I will give you a ride for $20. You just say, come on, hop in. You give me the ride downtown. Maybe you don't say anything. I get in your car and you take me to my office. You've performed your part of the contract. I can't then get out of my obligation by saying, well, you never accepted verbally. You accepted by performing your obligation under the contract. So that is another way of acceptance. So again, best practice, always put it in writing. Everything, as specific as you can. Even if it's just an offer, even if it's your acceptance, even if it's not the whole contract, put it in writing, because that will save you headache down the road if there's a disagreement. But just because it's not in writing does not automatically mean you don't have a contract. In some situations, which we're going to talk about next class, it has to be in writing or else there's nothing. There's some categories of contracts that have to be in writing, but not all of them. All right, so that is all I wanted to talk about today. Thursday, I will continue lecturing. The only thing I need you to do this week for Business Law is to read the lecture outline. Nobody has any questions, I will see y'all Thursday.